evening, and welcome to this night's edition of Court Watch. My name is Alexandra Hernandez.
And I'm Matthew Zipple.
Our first court case up tonight is Lawrence v. Texas. In Bowers v. Hardwick, the Supreme Court upheld a Georgia sodomy law criminalizing consensual homosexual intercourse. The court upheld that the Constitution did not confer a fundamental right to engage in homosexual sodomy.
In Houston, Texas, police were dispatched to Lawrence's apartment in response to a reported disturbance in the neighborhood. Upon the police's arrival, they found Lawrence and Garner engaged in sexual activity. The two men were charged and convicted under a Texas law concerning sexual intercourse with a member of the same sex. Lawrence and Garner challenged the law as a violation of the Equal Protection Clause of the 14th Amendment. Both men were each fined $200 and ordered to pay $141.25 in court costs. The Court of Appeals heard their federal constitutional arguments under the Equal Protection Clause and the Due Process Clause of the 14th Amendment. However, after hearing the case, the court rejected the arguments and held the convictions. Lawrence and Garner then appealed to the Supreme Court of the United States of America.
The 6-3 decision on the case was delivered by Justice Anthony Kennedy. The decision declared unconstitutional the Texas law that prohibited sexual acts between same-sex couples. Kennedy's majority opinion declared that there is a fundamental right given to consenting adults to engage in private sexual activity. The court also overruled Bowers v. Hardwick and thus held that the Texas sodomy law violated the right to privacy under the Due Process Clause of the 14th Amendment.
Justice Scalia, joined by Chief Justice Rehnquist and Justice Thomas, dissented. Justice Scalia stated that the court was not justified in overruling the precedent of Bowers. Scalia's dissenting opinion argued that states should be the ones who are able to make the moral judgment concerning homosexual conduct. State courts should therefore be allowed to state that this conduct is wrong and be able to apply this judgment in criminal statutes.
Next up is Bethel School District v. Fraser.
Bethel v. Fraser. It's a Supreme Court case that deals with free speech in public schools. Matthew Fraser was suspended from school for making a speech full of sexual double entendres at a school assembly. Specifically, on April 26, 1983, Matthew Fraser read the following speech, nominating his friend and classmate Jeff Coleman for Associated Student Body Vice President. Fraser's speech read as follows, and those who are easily disturbed ought to skip this segment of the show. I know a man who is firm. He's firm in his pants. He's firm in his shirt. His character is firm. But most of all, his belief in the students of Bethel is firm. Jeff Coleman is a man who takes his points and pounds it in. If necessary, he'll take an issue and nail it to the wall. He doesn't attack things in spurts. He drives hard, pushing and pushing until finally he succeeds. Jeff is a man who will go to the very end, even the climax, for each and every one of you. So please vote for Jeff Coleman. He is firm enough to give it everything. After appealing through the grievance procedures of the school, Fraser was still found to be in violation of a school policy which prohibited disruptive behavior. With approval of his parents and help from the ACLU, cooperating attorney Jeff Haley, Matthew Fraser filed a lawsuit against the school authorities claiming a violation of his First Amendment freedom of speech rights. And the U.S. District Court Judge Jack Tanner ruled in his favor. The school district then appealed the decision to the U.S. Ninth Circuit Court of Appeals, which ruled in Fraser's favor again with a broadly worded opinion. The school district again appealed to the United States Supreme Court. The U.S. Supreme Court reversed the Court of Appeals in a 7-2 vote to uphold the suspension, saying that the school district's policy did not violate the First Amendment. Chief Justice Warren Burger delivered the court's opinion in what ended up, along with the Graham-Rudman decision, to be the final case of the Burger Court era. Fraser refers to this as, quote, the silver lining in the grim cloud of my defeat. Justices William J. Brennan and Harry Blackmun delivered concurring opinions, while Thurgood Marshall and John Paul Stevens dissented. The majority opinion stated that because of the special circumstances that surround a school environment, that schools must have significant latitude in disciplining on-campus speech when it is believed to cause a substantial and material disruption of the learning environment of the school.
This moment brought to you by Sophocate.
And welcome back to Court Watch. Our next next court case is Vernonia School District v. Acton. In the mid-1980s, officials in the school district in Vernonia noticed a precipitous rise in drug use among the students in the Vernonia School District. Discipline problems rose in frequency and severity. Student athletes were the leaders of the drug culture prevalent among Vernonia students. At the trial, the Vernonia high school football and wrestling coaches noted that they had witnessed injuries attributable to student drug use. In response, the school district offered special classes, speakers, and presentations to the students intended to deter drug use. It brought in a specially trained dog to detect drugs, but the drug problem continued unabated. After inviting comments from the parents of the district students, the district adopted a drug testing plan. The U.S. Supreme Court decision, which upheld the constitutionality of random drug testing regimen implemented by the local public schools in Vernonia, Oregon. Under that regimen, student athletes were required to submit to random drug testing before being allowed to participate in sports. The majority opinion was written by Justice Scalia and joined by Justice Rehnquist, Justice Kennedy, Justice Thomas, Justice Ginsburg, and Justice Breyer. The dissent was written by Justice O'Connor and was joined by Justice Stevens and Justice Souter. In the dissent, Justice O'Connor dissented the court's decision because it did not rest on the requirement of individualized suspicion and did not adequately explain why individualized suspicion was not required in this context.
This is where you're supposed to make a transition, Alexandra.
Next up is New York Times v. Sullivan.
On March 29, 1960, the New York Times carried a full-page advertisement titled, quote, "Heed their rising voices," which solicited funds to defend Martin Luther King Jr. against an Alabama perjury indictment. The advertisement described actions against civil rights protesters, some of them inaccurately, some of which involved the police force of Montgomery, Alabama. Referring to the Alabama State Police, the advertisement stated that, quote, "They have arrested King 7 times. However, at that point, he had only been arrested 4 times. Although the Montgomery Public Safety Commissioner, L.B. Sullivan, was not named in the advertisement, the inaccurate criticism of the actions by the police was considered as defamation against him, as well by virtue of his position and duty to supervise the police department. Alabama law denied a public officer recovery of punitive damages in a libel action brought on account of a publication concerning their official conduct unless they first make a written demand for public retraction and the defendant fails or refuses to comply. So Sullivan sent such a request. The New York Times did not publish a retraction and in fact responded, quote, "We are somewhat puzzled as to how you think the statements in any way reflect on you, and, quote, you might, if you desire, let us know in what respect you claim that the statements in the advertisement reflect on you," end quote. Sullivan did not respond, but instead filed this libel suit a few days later. He also sued 4 black ministers mentioned in the ad, specifically Ralph Abernathy, S.S. Say, Sr., Fred Shuttlesworth, and Joseph Lowry. Sullivan won $500,000 in an Alabama court judgment. The Times appealed, and upon arriving at the Supreme Court ruled in favor of the Times 9-0. The rule of law applied by the Alabama courts was found constitutionally deficient for failure to provide the safeguards for freedom of speech and freedom of the press that are required by the First and 14th Amendments in a libel action brought by a public official against critics of his official conduct. The decision further held that under the proper safeguards, the evidence presented in this case is constitutionally insufficient to support the judgment for Sullivan. The majority opinion held that in order for a libel case to be found in favor of the person who's being libeled, the person being libeled must be able to demonstrate that actual malice was present on the behalf of the libelers. Justice Black explained that, quote, "Malice, even as defined by the court, is an elusive, abstract concept, hard to prove and hard to disprove. The requirement that malice be proved provides at best an evanescent protection for the right critically to discuss public affairs and certainly does not measure up to the sturdy safeguard embodied in the First Amendment." So in summary, the majority opinion created a safeguard for the First Amendment in the requirement of actual malice, though admittedly the Supreme Court is not fully protecting First Amendment rights.
And now, everyone here at Court Watch is excited to introduce a new segment that we like to call the Capetanos Report. John, take it away.
Thank you, Alexandra. Tonight on the Capetanos Report, we have 2 very interesting Supreme Court cases. Abrams versus United States, which deals with free speech, and Engel versus Vitale, which deals with the free exercise clause of the United United States Constitution. Abrams versus United States was a 7-2 decision of the United States Supreme Court involving the 1918 amendment to the Espionage Act of 1917, which made it a criminal offense to urge curtailment of production of materials necessary to the war against Germany with intent to hinder the progress of the war. The 1918 amendment is commonly referred to as the Sedition Act. The defendants were convicted on the basis of 2 leaflets they printed and threw from windows of a building in New York City. One leaflet denounced the sending of American troops to Russia. The second leaflet denounced the war and the U.S. efforts to impede the Russian Revolution and advocated the cessation of production of weapons to be used against Soviet Russia. The defendants were charged and convicted for inciting resistance to the war effort and for urging curtailment of production of essential war materials. They were sentenced to 20 years in prison. They appealed to the Supreme Court on the basis of the Free Speech Clause of the First Amendment. The Supreme Court ruled 7-2 that the Sedition Act did not violate the freedom of speech protected by the First Amendment. Justice John Hesson Clark used a relatively restrictive speech test, bad tendency, to uphold the conviction. Justices Oliver Wendell Holmes and Louis Brandeis, Holmes being a justice who earlier defended the Sedition Act and the Espionage Act, wrote the dissent and said that the more speech protective standard, clear and present danger, ought to be applied to overturn the conviction. Writing for the majority, Justice John Hesson Clark asserted that the leaflets were an appeal to violence against the United States government as opposed to peaceful change. Clark wrote that this is not an attempt to bring about a change of administration by candid discussion. No matter what may have incited the outbreak on the part of the defendant anarchists, the manifest purpose of such a publication was to create an attempt to defeat the war plans of the government of the United States. This case was ultimately overturned during the Vietnam War era in Brandenburg versus Ohio.
Action.
Engel v. Vitale. In 1951, the New York State Board of Regents, the State Board of Education, approved a 22-word non-denominational prayer for recitation every morning in the public schools of New York. It read, "Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country." The Regents believed that the prayer could be a useful tool for the development of character and good citizenship among the students of the state of New York. The parents of 10 pupils in the New York Hyde Park schools objected to the prayer. They filed suit at a New York State court seeking a ban on the prayer, insisting that the use of this official prayer in the public schools was contrary to their own and their children's beliefs, religions, and religious practices. The state court upheld the use of the prayer. It was later brought to the Supreme Court under the Free Exercise Clause. The court, in a 6-1 majority, found that the New York Regents' prayer to be unconstitutional. Justice Hugo Black wrote the opinion. "There can, of course, be no doubt that the New York programs of daily classroom invocation of God's blessings in the Regents' prayer is a religious activity," Black wrote. "We think that by using the public school system to encourage recitation of the Regents' prayer, the state of New York has adopted a practice wholly inconsistent with the Establishment Clause." The court's decision was not, Black pointed out, anti-religious. It sought, rather, only to affirm the separation between church and state. This has been the Capetanos Report. Thank you, and have a good night.